If it allows, we're gonna go into the study session with Mansa Manhattan. We're gonna be reading from Federal Reserve Section 16, Note Issues.
16. All right, we're going to go ahead and go down. All right. All right. As you can see, Section 16 speaks about note issues.
What we're gonna do is read it first, right? You gotta get it first. Then if you don't understand, somebody will break it down for you. So let me see. Note issues. Section 16, Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to Federal Reserve banks through the Federal Reserve agents as hereinafter set forth and for no other purpose or hereby authorized. The said notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks, and for all taxes, customs, and other public dues, they shall be redeemed in lawful money on demand at the Treasury Department of the United States in the city of Washington, District of Columbia, or at any Federal Reserve Bank codified at 12 USC 411. 2. Application for notes by Federal Reserve banks. Any Federal Reserve Bank may make application to the local Federal Reserve agent for such amount of the Federal Reserve notes herein before provided for as it may require. Such application shall be accompanied with a tender to the local Federal Reserve agent of collateral in amount equal to the sum of the Federal Reserve notes thus applied for and issued pursuant to such application. The collateral security thus offered shall be notes, drafts, bills of exchange, or acceptance acquired under Section 10A, 10B, 13, or 13A of this Act, or bills of exchange endorsed by a member bank of any Federal Reserve district and purchased under the provisions of Section 14 of this Act, or bankers' acceptance purchased under the provisions of said Section 14, or gold certificates, or special drawing right certificates, or any obligations which are direct obligations of or are fully guaranteed as to principal and interest by the United States or any agency thereof, or assets that Federal Reserve banks may purchase or hold under Section 14 of this Act, or any other asset of the Federal Reserve Bank. In no event shall such collateral security be less than the amount of Federal Reserve notes applied for. The Federal Reserve agent shall each day notify the Board of Governors of the Federal Reserve System. The Federal Reserve agent shall each day notify the Board of Governors of the Federal Reserve System of all issues and withdrawals of Federal Reserve notes to and by the Federal Reserve Bank to which he is accredited. The said Board of Governors of the Federal Reserve System may at any time call upon a Federal Reserve Bank for additional securities to protect the Federal Reserve notes issued to it. Collateral shall not be required for Federal Reserve notes which are held in the vaults of are otherwise held by or on behalf of Federal Reserve banks, 12 USC 412. 3. Distinctive letter on notes. Destruction of unit of destruction of unfit notes. Federal Reserve notes shall bear upon their faces a distinctive letter and several number uh, and serial number. Let me read that one over. Federal Reserve notes shall bear upon their face a distinctive letter and serial number, which shall be assigned by the Board of Governors of the Federal Reserve System to each Federal Reserve Bank. Federal Reserve notes unfit for circulation shall be canceled, destroyed, and accounted for under procedures prescribed and at locations designated by the Secretary of the Treasury. Upon destruction of such notes, credit with respect thereto shall be apportioned among the 12 Federal Reserve banks as determined by the Board of Governors of the Federal Reserve System. That'll be under codified under 12 USC 413. 4. Granting right to issue notes. The Board of Governors of the Federal Reserve System shall have the right, acting through the Federal Reserve agent, to grant in whole or in part, or to reject entirely the application of any Federal Reserve bank for Federal Reserve notes, but to the extent that such application may be granted, the Board of Governors of the Federal Reserve System shall, through its local Federal Reserve agent, supply Federal Reserve notes to the banks so applying, and such bank shall be charged with the amount of the notes issued to it, and shall pay such rate of interest as may be established by the Board of Governors of the Federal Reserve System on only that amount of such notes which equals the total amount of its outstanding Federal Reserve notes, less than amount of gold certificates held by the Federal Reserve agent as collateral security. Federal Reserve notes issued at any such bank shall, upon delivery, together with such notes of such Federal Reserve Bank as may be issued under Section 18 of this Act, upon security of United States 2% government bonds, become a first and paramount lien on all the assets of such bank, codified in 12 USC 414. 5. Deposit to reduce liability for outstanding notes. Any Federal Reserve Bank may, at any time, reduce its liability for outstanding Federal Reserve notes by depositing with the Federal Reserve agent its Federal Reserve notes, gold certificates, special drawing rights certificates, or lawful money of the United States. Federal Reserve notes so deposited shall not be reissued except upon compliance with the conditions of an original issue. The liability of the Federal Reserve Bank with respect to its outstanding Federal Reserve notes shall be reduced by any amount paid by such bank to the Secretary of Treasury under Section 4 of the Old Series Currency Adjustment Act. 12, codified 12 USC 415, 6, substitution of collateral, retirement of Federal Reserve notes. Any Federal Reserve bank may, at its discretion without collateral deposited with the local Federal Reserve agent for the protection of its Federal Reserve notes issued to it, and shall at the same time substitute therefore other collateral of equal amount with the approval of the Federal Reserve agent under regulations to be prescribed by the Board of Governors of the Federal Reserve System. Any Federal Reserve Bank may retire any of its Federal Reserve notes by depositing them with the Federal Reserve agent or with the Treasury of the United States, and such Federal Reserve Bank shall thereupon be entitled to receive back the collateral deposited with the Federal Reserve agent for the security of such notes. Any Federal Reserve Bank shall further be entitled to receive back the collateral deposited with the Federal Reserve agent for the security of any notes with respect to which such bank has made payment to the Secretary of the Treasury under Section 4 of the Old Series Currency Adjustment Act. Federal Reserve notes so deposited shall not be reissued except upon compliance with the conditions of an original issue. Codified at 12 USC 415. 7. Custody of federal custody of reserve notes, gold certificates, and lawful money. Custody of reserve notes, gold certificates, and lawful money. All Federal Reserve notes and all gold certificates, special drawing rights certificates, and lawful money issued to or deposited with any Federal Reserve agent under the provisions of the Federal Reserve Act shall hereafter be held for such agent under such rules and regulations as the Board of Governors of the Federal Reserve System may prescribe, in the joint custody of himself and the Federal Reserve Bank to which he is accredited. Such agent and such Federal Reserve Bank shall be jointly liable for the safekeeping of such Federal Reserve notes, gold certificates, special drawing rights certificates, and lawful money. Nothing herein contained, however, shall be construed to prohibit it, a Federal Reserve agent from depositing gold certificates and special drawing rights certificates with the Board of Governors of the Federal Reserve System to be held by such board subject to his order or with the Treasurer of the United States for the purposes authorized by law, codified at 12 USC 417. 8. Engaging in plates, denominations, and form of notes in order to furnish suitable notes for circulation of Federal Reserve notes. The Secretary of the Treasury shall cause plates and dies to be engaged in the best manner to guard against counterfeits and fraudulent alterations, and shall have printed therefrom and numbered such qualities of such notes of the denomination of $1, $2, $5, $10, $20, $50, $100, $500, $1,000, 5,000, and $10,000, and may be required to supply the Federal Reserve Bank. Such notes shall be in the form and tender as tenor as directed by the Secretary of the Treasury under the provisions of this act, and shall bear the distinctive number and the several Federal Reserve banks through which they are issued. codified at 12 USC 418. 9. Custody of unissued notes. When such notes have been prepared, the notes shall be delivered to the Board of Governors of the Federal Reserve System, subject to the order of the Secretary of Treasury, for delivery of such notes in accordance with this act under 12 USC 419. Number 10, custody of plates and dies, expenses of issue and retirement of notes. The plates and dies to be procured by the Secretary of Treasury for the printing of such circulating notes shall remain under his control or discretion or direction, control and direction, and the expenses necessarily incurred in executing the laws relating to the procuring of such notes and all other expenses incidental to their issue and retirement shall be paid by Federal Reserve banks, and the Board of Governors of the Federal Reserve System shall include in its estimate of expenses levied against the Federal Reserve Bank a sufficient amount to cover the expenses herein provided for. 12 USC 420. 11. Uh, examinations of plates, dies, etc. The Secretary of the Treasury may examine the plates, dies, bed pieces, and other material used in the printing of Federal Reserve notes and issue regulations relating to such examinations codified at 12 USC 421. This is 12, appropriation for engraving, etc. Any appropriation heretofore made out of the general funds of the Treasury for engraving plates and dies, the purchase of distinctive paper, or to cover any other expense in connection with the printing of national banknotes or notes provided for by the Act of May 13th, 30th, May 30th, 19 and 8. Oh, 908. So that's May 30th, 1908. And any distinctive paper that may be on hand at the time of the passage of this act may be used in the discretion of the Secretary for the purposes of this act and shall be appropriations heretofore heretofore made by insufficient to meet the requirements of this act in addition to circulate notes provided for by existing law. Existing law. The Secretary is held authorized to use so much of any funds in the Treasury not otherwise appropriated for the purpose of furnishing the notes aforesaid, provided, however, that nothing in this section contained shall be construed as attempting natural banks and Federal Reserve banks from their liability to reimburse the United States for any expenses incurred in printing and issuing circulation notes omitted from United States Code 13. Checks and drafts to be received on deposit at par. Every Federal Reserve Bank shall receive on deposit at par from depository institutions or from Federal Reserve Banks checks and other items, including negotiable orders of withdrawals and share drafts and drafts drawn upon any of its depositors and when remitted by the Federal Reserve Bank's checks and other items, including the negotiable orders of withdrawal and share drafts and drafts drawn by any depositor in any other Federal Reserve Bank or depository institution upon funds to be credit of said depositor in said Reserve Bank or depositor institution. Nothing herein contained shall be construed as prohibiting depository institution from charging its actual expense incurred in collateral and remitting funds or for exchange sold to its patrons. The Board of Governors of the Federal Reserve System shall, by rule, fix the charges to be collected by the depository institutions for its patrons whose checks and other items, including negotiable orders of withdrawal and share drafts, are cleared through the Federal Reserve Bank and are charged with which may be imposed for for the service of clearing and collecting rendering by the Federal Reserve Bank, codified at 12 USC 360, transfer of funds among Federal Reserve banks. The Board of Governors of the Federal Reserve System shall make and promulgate from time to time regulations governing the transfer of funds and charges, therefore, among Federal Reserve banks and their branches, and may at its discretion exercise the functions of a clearinghouse for such Federal Reserve banks, or may be designated a Federal Reserve Bank to exercise such functions, and may also require each bank to exercise the functions of a clearinghouse for depository institutions, codified at 12 USC 248.0. Number 15, Settlement Fund. The Secretary of Treasury is hereby authorized and directed to receive deposits of gold or of gold certificates or of special drawing rights certificates with the Treasury or any assistant treasurer of the United States when tendered by any Federal Reserve Bank or Federal Reserve agent for credit to its or his account with the Board of Governors for the Federal Reserve System. The Secretary shall prescribe by regulation the form of receipt to be issued by the Treasurer or Assistant Treasurer to the Federal Reserve Bank or Federal Reserve agent making the deposit, and a duplicate of such receipt shall be delivered to the Board of Governors of the Federal Reserve System by the Treasurer at Washington of the Federal Reserve System by the Treasurer at Washington upon proper advices from an assistant treasurer that such deposit has been made, deposits so made shall be held subject to the orders of the Board of Governors of the Federal Reserve System, and deposits of gold or gold certificates shall be payable, and gold certificates and deposited of special drawing rights. Certificates shall be payable in special drawing rights. Oh, certificates. The special drawing rights certificates on the order of the Board of Governors of the Federal Reserve System to any Federal Reserve Bank or Federal Reserve agent at the Treasury or at the Sub-Treasury of the United States nearest the place of business of such Federal Reserve Bank or such Federal Reserve agent. The order used by the Board of Governors of the Federal Reserve System in making such payments shall be signed by the chairman or by regulation prescribed in form of such order shall be approved by the Secretary of Treasury, codified at 12 USC 467. 16 expenses. The expenses necessary incurs in carrying out these provisions, including the cost of the certificates, the receipts issued for deposits received, and all expenses incident to the handling of such deposits shall be paid by the Board of Governors of the Federal Reserve System, and includes in its assessments against the several Federal Reserve banks as codified at 12 USC 467. 17. Preservation of provisions of Act of March 14th, 1900. Nothing in this section shall be construed as amending Section 6 of the Act of March 14th, 1900, as amended by the Acts of March 4th, 1907, March 2nd, 1911, and June 12th, 1916. Nor shall the provisions of this section be construed to apply to the deposits made or to the receipts or certificates issued under those acts. 12 USC 467. Repeal of provisions requiring national banks to deposit bonds with United States Treasurer. And we had section 17. That's all we needed was 16. Let's go back to 16. And we finished this section right here, there, guys. And it's called No Issues. And we're going to come back